And I'm Ben Lorraine. I'm the executive director here at the New Israel Fund, and I'm really delighted to host this very fascinating conversation today. Before we begin, I would like to acknowledge just that here in Toronto, where I sit, I'm on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and that this is now home to many diverse First Nations, Inuit, and Métis peoples. And I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Those of you who are joining from elsewhere in Canada, and therefore sit in different Indigenous territory, I encourage you to take a moment to reflect and acknowledge this, no matter where you are. Thank you. As we begin, last week's election results are not last week's, but last month's election results from Israel are difficult for all who believe in Israel as a liberal democracy. This outcome did not come as a total surprise. It is the culmination of more than a decade of growing illiberal trends in Israel, like anti-democratic legislation such as the nation-state law, attacks on civil society, NGOs, the media, and the courts, over 50 years of occupation and more. This incoming government, which is not even official yet, will likely attempt to entrench their vision of majoritarian rule over Israeli society. And one of the preeminent pieces of their wish list is passing a court override law, allowing the Knesset to overrule the Supreme Court. The New Israel Fund of Canada and the New Israel Fund in Israel cares deeply about these issues because we are the leading force supporting, funding, training, and advocating for and with Israeli social justice, civil rights, human rights, and civil liberties organizations, and we have been doing so for 40 years. Those advancing in Israel this court override have pointed directly to Canada's notwithstanding clause as legitimacy for their vision. But is the comparison accurate? Even if it's accurate, is such a tool truly democratic? What is the founding purposes behind these tools? And what lessons has Canada learned that may be relevant to Israel? So today, this is why we have three distinguished speakers to address these questions and more. We'll hear from each of them, and then we'll have a brief time at the end for Q&A. We will end on the hour. So first, in the order of our speakers, joining us is Professor Lorraine Weinrib of U of T. In her previous lives, she was counsel for Ministry of the Attorney General of Ontario, Attorney Director of Constitutional Law and Policy also. She led the SEC case on Canada's notwithstanding clause, sustaining the prohibition against retroactive implementation, and she will explain what all that means. She's been a professor at U of T Law School since 1988, teaching constitutional law, and has a huge depth of experience specifically with the appropriateness of Canada's charter as a model for Israel's basic laws. Lorraine, we're delighted to have you. Noah Mendelsohn Aviv is the executive director of the Association for Civil Rights for the Canadian Civil Liberties Association. She joined it in 2002 and has directed both CCLA's equality and freedom of expression programs. She's written, appeared, and advocated on a whole host of civil liberties issues, stewarded legislation for the organization, appeared before parliamentary and provincial legislative committees. She became the executive director within the past year or two, and she is joining us as a member of INGLO, the global overarching organization that both CCLA and our next speaker, ACRI, are members of. So our third speaker is Rabbi Noah Sattath, who took the helm of the Association for Civil Rights in Israel, known as ACRI, in also very recently, November 2021. Noah is an ordained Reform rabbi and spent the past 11 years as executive director of the Israel Religious Action Center of the Reform movement in Israel, where she was responsible for leading the organization's strategy on religion and state, gender equality, the fight against racism. She's been a leader in many social struggles, and prior to Iraq, she served as the director of the Jerusalem Open House, where she aided the historic move to lead the first Pride March in Jerusalem. Both of them have been, all three of our speakers are very involved in other causes as well, and their bios go on for quite long. But let's actually get into the content. So first, we would love to help set history and context with Lorraine. Professor Weinrib, would you help us understand what we're looking at here?
Thank you very much for the invitation to participate. My topic today is democracy. Those now engaged in coalition negotiations in Israel legitimate the process of committing the new Israeli government to specific substantive and institutional measures by appeal to their electoral mandates and to the cumulative majority their parties enjoy in the new Knesset. In doing so, they ignore the prevailing paradigm of democracy in the post-Second World War era, rights-based democracy. Indeed, their proposals are textbook examples of repudiation of the new conceptualization of democracy, including the elements of that model that are now operative within Israeli law and politics, based on basic laws that protect rights. Many of the elements of rights protection in Israel under these basic laws are modeled on Canada's charter. The formulation of the rights in the text, and the idea that the text is interpreted and applied through a methodology signaled in the text, which involves purposive interpretation of the rights and freedoms according to, among other elements, their fundamental conceptual foundation, and limited normative justification of limits on those rights. The override is not, therefore, the only Canadian import into Israeli constitutional law. Rights-based democracy is not merely a post-Second World model of democracy. It is post-Holocaust, and it is characterized in Germany, the country that has the clearest theoretical and institutional model of rights-based democracy, as a never again model. I conclude from the post-Holocaust timing and the never again orientation is that the ideas embodied in the post-war rights-based democratic model are not totally alien to Israeli history and values. At its core, this new model of democracy conceptualizes the relationship between the individual and the group to the state. It developed based on the paramount commitment to fundamental rights. It displaces majoritarian democracy and its partner, legislative supremacy. The core idea is to impose on the state by supreme law and or by international and or by regional law a bifurcated duty. In negative terms, it is to respect, and in positive terms, it is to protect the equal and inherent human dignity of all persons subject to the authority of the state. Rights-based democracy operates most optimally and in a most concrete sense at the national level, supported by regional and or international human rights norms. It takes the form in the nation state as a comprehensive constitutional framework having the status of supreme law, difficult to amend or in some circumstances excluded from amendment. Full judicial enforcement by specialized courts or by Supreme Courts, have full remedial authority over all state actors and legislation. We see the fullest formal delineation in nation states that were reconstructed from defeated or failed states immediately after the war or later. This is the purest model because the circumstances of constitutional creation require no allegiance to custom, tradition, or existing political or demographic hierarchies. We see this example, including a full institutional support for it in countries like Germany and South Africa. In contrast, somewhat ironically, the model thrives but is much less robust in the victor states after the Second World War, because the transformation is informal rather than formal, based to a great extent on innovative interpretation of pre-World War II constitutional texts. And the strong example of this is the United States. And there were failed attempts to have statutory and judicial rights protection in Canada that ultimately led to the final resort for rights protection, the Charter. Unfortunately, we now see the flowering of this model in the post-war period, the work of the American Supreme Court now being successfully attacked by those who do not support rights-based democracy. Canada and Israel, of course, are neither failed nor victor states in the post-war model. They present a third model, rights protection grafted onto the legal systems with common law and civil law roots, and the British understanding of unwritten constitutionalism based on principles and court delineation and legislative self-restraint. Canada's charter stands as the product of decades of deliberation on the place that rights protection should hold in the hierarchy of our legal system. The breakthrough to the charter is not, as it is often referred to in Israel, the triumph of the federal government's support for the charter and the defeat of provincial opposition to the charter. Rather, the adoption of the charter as a strong rights protecting instrument with the override was precipitated by civil society groups and identity groups, social justice groups, legal experts who participated in parliamentary hearings that were extensive and wide-ranging, which provided so much legitimacy for the charter that the opposing premiers had to relent and agree to a charter with their compromise proposal of including the notwithstanding clause. The charter's override clause is not a plenary grant of power. It applies only to some rights, and there are different explanations for the distinction. It is temporary. It operates when invoked for a 5-year maximum, which coincides roughly with election frequency. Then it must lapse. If a provincial or federal government wants to reinstate it, it must be reenacted. It is subject to litigation because it is a delegated power. And there have been examples of, one example of court restriction on the exercise of the override, which is interpolated from the text, but I think it's more accurate to say interpolated from its exceptionality from some legal protection of the most important fundamental norms of the relationship between the individual, the group, and the state. I was responsible for the only judicial restriction on the exercise of the override when I represented the province of Ontario as an intervener in the only Supreme Court of Canada deliberations so far on the notwithstanding clause. I argued on principles and interpretation of the constitutional text, and I was successful. If the override could be used retroactively, it would actually mean that the charter protections would never be forcible, because it would be possible years, months later for a government to reach back in time and retroactively take away rights that had been exercised in real time when the rights were in play. There are different mechanisms that dissuade governments from renewing the override, including local, national, and international objection and expert deliberation and examination of the effect of the deprivation of rights on the people whose rights are removed. There is also a requirement of specificity, which I think has to be deliberated upon by the Supreme Court. The text does not allow for the override of all rights, as I've said, but it doesn't, but for the rights that are subject to the override, there is a specification of overriding a provision, which, and some charter rights sections in the charter contain a number of rights. So it seems as an idea that specificity will increase the political accountability when a legislature invokes the override. It has to be done by legislation. We've had several examples of very cursory legislative process, and I hope the Supreme Court of Canada will reject that approach. There are other sections of the Charter, general interpretive sections, as well as another notwithstanding clause in favor of gender equality, to which the interpretation of the override should be rendered. There's a question being deliberated now in the academic literature in Canada as to whether the override can be used preemptively, or whether so that there can never be judicial review, and I think that that will be rejected. The proposals that I've read in the press for the override in the sort of new government's coalition agreement are in process and in substance repudiations of rights-based democracy. The process is not transparent. The claim that it is majoritarian is very suspect. Small coalitions, coalition partners, and very little public discussion, even to the extent that in the press it's reported that the Prime Minister does not want the content content of the proposals made public because of the political cost. In substance, there are proposed changes to criminal law retroactively to benefit the Prime Minister and another prominent politician. Changes in the political control of the appointment of the Supreme Court itself, High Court of Justice, government advisors, restrictions on standing to bring constitutional litigation, changes in the office of the Attorney General, removal of the reasonable standard reasonableness standard and the minister of law, changes to the authority of the police. These are monumental transformations of the relationship between the state and individual and groups in Canada, and to the institutions that have the role to protect these people from excess encroachment of equal and inherent human dignity of individuals and members of identity groups in Israel. There is not much opportunity for public debate when the proceedings are not public, but it is to be hoped that the elements that we are reading about will not be fully implemented. Thank you.
Thank you, Lorraine. There's obviously lots more to get into, but I think it's weighty coming from you, someone who is so intimately involved in Canada's own notwithstanding clause and its successive interpretation. Even just the 15 minutes that we've had from you, I think carries outsized weight in understanding our context and looking at the incoming context. So with that, let's look to our two Noahs to help us understand the further comparison. So again, let's Noah Mendelsohn Aviv. I believe you're going to go first. Thank you so much. It's great to have you as a friend and partner. So please share with us your thoughts.
Thank you very much, Ben. And thank you everybody for being here to talk about this extremely important and very worrying non-development development, because there has been some movement, even though the notwithstanding clause has been with us since the inception of the Charter. As Professor Weinrib told you, Canada's notwithstanding clause is, I don't think she used the word terrifying, it is a terrifying legal provision that on some interpretations, including the governing decision from the Supreme Court of Canada, can be used almost without any restriction by any provincial government or the federal government to limit almost any key right and freedom in the Charter, including, and I'm going to name them because it's important, speech, freedom of religion, freedom of the press, protest rights, freedom of association and other workers' rights, privacy, the right to counsel, habeas corpus, equality rights, the right to be free from arbitrary detention, the presumption of innocence, life, liberty, and security of the person. All of those are on the chopping block if a government invokes the notwithstanding clause, and it's going to be up to the courts to see what they do with it, and we're still fighting that. I'm going to talk about that in a moment. The most meaningful and effective means of limiting its use seems right now to be political. The damage that can be caused by a public outcry was always supposed to stop governments in the first place from using the notwithstanding clause. And I'll talk about how that happened in Ontario very recently, as many of you are probably aware. Beyond public outcry, it's not clear what restrictions there are on its use. There are certainly very few explicit ones written into this section itself, and it hasn't been used often. But, as you've heard, the Ford decision of 1988 said that the clause can be used in an omnibus bill relating to many laws, and that it did not require that specific provisions be spelled out, and that other restrictions that were substantive probably couldn't be used either, although those were not at issue in Ford. The notwithstanding clause has been invoked by 4 provinces and 1 territory: Quebec, Yukon, Saskatchewan, Alberta, and Ontario. And the most egregious uses to violate fundamental rights and freedoms have been those of the past few years in Quebec and Ontario. So I'll start with one of the biggies in Quebec, and that's Bill 21, to share with you what happened and how badly the notwithstanding clause has harmed people's fundamental rights, religious minorities. June 2019, the Quebec National Assembly passed Bill 21, the Laïcité Act. Activists still refer to it by its bill name, Bill 21, that prohibits public sector workers from wearing religious symbols while performing their duties. This includes teachers, judges, lawyers working for the government, crowns or contract police officers. Bill 1 also prohibits certain public sector workers from wearing a face veil, a face covering, from those who work in the public sector for reasons of identity or security purposes. The effects of this law, according to the Quebec Superior Court that heard it, have been cruel and dehumanizing. And the court found the greatest harm has been to women, in particular Muslim women who wear the hijab, many of whom come from minority, religious, racialized, and immigrant communities. It has also harmed Sikh people. It has also harmed Jewish people. And there are witnesses in that case who have talked about what it has done to them, both in terms of their practical day-to-day lives and their income, and in terms of their ability to remain in a province where their children are second-class citizens, and people are moving and people are feeling pushed out. And this is all lawful so far, according to the courts. The law has in particular harmed women's ability to work in their profession, their financial freedom, their independence. The law says to Jewish kids, to Muslim kids, to Sikh kids, if you practice your religion a certain way, the sky is not the limit. You cannot grow up to be anything you want. Certain doors are shut to you. You are less equal. I realize that's not really a possibility. And since the law was passed, it has emboldened a portion of the population, and there are more reports of racial harassment and intimidation and even assaults, and that has been studied. There are people in Quebec, many of them, who believe that Bill 21 is a good thing. Some of them because they believe that it liberates women from the hijab and from what they stereotypically believe to be abusive or coercive requirements to wear this symbol. The evidence shows that this is not the case. Sociological studies, as well as many witnesses who came forward to the court, demonstrate that women who wear niqab and hijab choose to do so, sometimes against the wishes of their family. And we heard that over and over again in court. People are thinking about Iran, where the situation is differently, where women are fighting courageously against coercion and for the freedom to choose what to wear and what not to wear. But in Quebec, the coercion is Bill 21 that takes away the choice from women who choose to wear the hijab as an article of faith or a symbol of identity. And here, like in so many other situations, the politics are being played out on women's bodies and against their freedom. And what Bill 21 is doing is it's not keeping religion out of public spaces, it's pushing people, Muslim women in particular, and other religious and racialized people out of public bodies. So that's why we're fighting it, and that's where the notwithstanding clause is getting in our way. When a predecessor to Bill 21 was introduced, and we fought that too, Bill 62, we immediately challenged it, and we asked the court to suspend the law, to stay the operation of the law until all the court proceedings could be heard and a decision could be rendered. And the court gave us that suspension, and Bill 62 was never operationalized because we were able to get it stopped. There was no withstanding clause used in Bill 62. When Bill 21 was passed, again, we partnered with the same Muslim organization and affected individuals. And again, we asked the court, we challenged it, we said it's unconstitutional, but we also asked the court to suspend the operation of the law until the matter could be properly heard and decided by the court. This law did invoke the notwithstanding clause, and here, time and again, courts refused to suspend the operation of a law that has caused enormous harm and inequality to people and harm to women and to their independence and freedoms. The lower court, the Superior Court in Quebec, refused to suspend the law, saying the law just got passed, there is no evidence of harm. We would argue otherwise. We believe that we brought evidence of harm and sidestepped the question of the notwithstanding clause. At the Quebec Court of Appeal, it was very different. The notwithstanding clause was fully before the court in their decision. And there we lost on a split decision. The Chief Justice, in a dissenting opinion, wanted to grant the injunction suspending the law and found that the act does harm female teachers. She found it prima facie, because of course this was just an injunction motion, that the act harms female teachers who wear the hijab. The two majority judges, for different reasons, declined to grant the suspension. Justice Bélanger said, and it's such a sad and worrying statement, she says, in the case at bar, the notwithstanding clause dictates that at this stage of the case, The courts must abandon to their fate women graduates who are willing to work and who, for the sole reason that they wear the veil, have been denied access to a job for which they hold all the skills. My hands are tied. I have to abandon to their fate these women. Justice Mainville of the Quebec Court of Appeal took it even further. He said that CCLA and our partners' arguments about the interplay between a gender equality provision in the Charter Section 28 and the notwithstanding clause did not satisfy him. He said that on an interim remedy motion, the question was too nebulous and embryonic to justify the suspension. We just don't know what to do with the notwithstanding clause. As for the Supreme Court of Canada, they denied us leave to appeal. So because the notwithstanding clause has not been used very often and even less adjudicated, the courts declined this suspension. The law has been in full force, creating these horrendously, legally mandated discrimination against Jewish, Catholic, Sikh, and Muslim individuals, in particular Muslim women. It's now over 3.5 years. Then we got our first decision from the Quebec Superior Court in April of 2021. Justice Blanchard ruled CCLA and the National Council of Canadian Muslims, again, with an affected individual, had our challenge, and we were joined by 3 other challenges, as well as many other interveners who raised many different kind of arguments about the lack of constitutionality of Bill 21 and about the limits that should be imposed on the use of the notwithstanding clause. And for the most part, we were unsuccessful with respect to the notwithstanding clause. As I mentioned earlier, there were several Jewish, Christian, Sikh, and Muslim witnesses who testified why they chose to wear the hijab and other religious symbols, including Muslim women who talked about their spirituality, who said it's important to their identity, some of whom said they wear it because they want to challenge stereotypes. They wear it for equality and they wear it for freedom, the ability to control their lives and their bodies and what they choose to show others. And they testified about the increased hatred and threats that they had experienced since Bill 21 had passed. And as I said earlier, the court concluded that this law was cruel and dehumanizing, and it was essentially anti-religious, but ultimately upheld most of it because of the notwithstanding clause. A lot of arguments were raised by the many parties and interveners about the notwithstanding clause, including looking for different arguments, different substantive conditions to limit the use of the override, such as clarity, a need for clarity and openness, respect for the democratic process, international legal obligations that should be read into it, and Section 1 of the Charter, the reasonable limits test. The court declined to accept any of these arguments because it felt bound by the Supreme Court's decision in the 1988 decision of Ford, but it made certain comments suggesting that the legislator's use, the Quebec National Assembly's use of the derogation clause, and they derogated as well from their own Quebec Charter of Human Rights and Freedoms, that those appeared excessive. The Quebec Superior Court hinted that it might have decided things differently if not for the binding precedent. I wouldn't want to comment on that. It's still before the courts, but here is what the court says. It said, in a society concerned with respecting the fundamental rights it grants to its members, the use of the notwithstanding clause should be sparing and circumspect. Some may think that the use made by the Quebec legislator in this case trivializes it, especially since the derogation comes before any judicial debate. And that's one of the arguments that has been raised that really the notwithstanding clause should not be used unless it's gone to court. The court also expressed strong concern about the scope of how the notwithstanding clause was used, calling it flippant and indifferent, suggesting that the use of the derogation power should remain exceptional. And the court hinted that if not for the Ford precedent, perhaps there could have been another restriction on the use of the notwithstanding clause requiring, and I quote, the legislature, the assembly, to be able to explain in the event of a challenge, at least justification for the decision to exercise the notwithstanding power, some connection between the suspension of rights and freedoms and the objectives pursued by the legislation in question. This would allow the court, in the event of a dispute, the court said, to scope out the use of the notwithstanding clauses to assess whether they are legally necessary for the legislature to achieve the purpose it seeks while respecting the very wide latitude it enjoys. So the Superior Court declined to grant a declaration of invalidity. It did not grant any relief under the gender equality provision of the Charter, Section 28, that it held was interpretive only, and did not override the override clause, and seems perhaps regretful of its inability to rule otherwise, and said that the response, the sanction for the use of the notwithstanding clause had to be found at the ballot box. We read the Quebec. Are we out of time?
We are. I gave you a couple.
Oh my goodness, so sorry. So I will, if I can just take one more minute. We were at the Quebec Court of Appeal, and of course, there's been this wonderful, successful public outcry to bring down Bill 28 that also invoked the notwithstanding clause in Ontario just a few weeks ago.
I think we'll have to save more for what is going to be a very brief Q&A session. But I want to make sure that we bring in, now that we've seen that the notwithstanding clause in Canada is not in and of itself so uncontroversial, and that the experts themselves are deeply worried about it, and that it leads to inequality, and that it leads to the violation of fundamental rights. Let us now speak with Rabbi Noah Sattath of ACRI in Israel, which is New Israel Fund's flagship partner. Let's hear from you. What are we looking at when we look at Israel's proposed, many versions proposed, override law, and what we're looking at with the incoming, not official, rather extreme Israeli government?
Thank you. Thank you so much for organizing this event. And thank you for Noah and Lorraine for your words, and Noah for your inspiring work for religious rights. I want to share a little bit about the override clause and its dangers, but first I want to kind of set the stage for how we talk after the Israeli elections. And our motto at ACRI is "We are ready." And being ready means looking at the threats as they appear from the history of the elected officials that we're looking at, and really looking deeply into the threats that may arise, and being prepared as much as we can be for what may come in the future. So it's going to be the threats that I'm going to share with you are going to be bleak. I'm warning you. And this is not a list of expectations. This is not my prophecy of what will happen. But ACRI has spent the weeks following the elections analyzing the map of threats to human rights and democracy in Israel. We looked at bills proposed by the incoming coalition members in previous Knessets. Knesset sessions. We looked at the negotiation agreements between the parties, and we looked at position papers by right-wing think tanks to create a map of potential threats, so that we can really have a full assessment of what could happen, and then that helps us prepare for each and every scenario. And we are ready to engage in a fierce struggle for every single right that is threatened. One of the and I'm happy to share later the full map of threats that we also have on the ACRI website. The threats to judicial independence are typical of authoritative leaders. In Israel, first of all, the map of checks and balances is completely different than in Canada. We have no constitution, so there's no barriers. We have only one House of Representatives, and the separation between the executive branch and the legislative branch is extremely weak. So the Supreme Court is really the major check and balance. The government is planning a host of measures to limit the power of the Supreme Court to oversee government policy and the Knesset legislation. And the chief or the first step plan seems to be the override clause. The override clause proposed, at least at this current moment, means that the Knesset can re-legislate laws that were struck down by the Supreme Court with a majority of 50% of the Knesset, the parliament members, plus one. So that's also a major difference than the Canadian law. In looking at what this could mean, we're looking at some short-term and longer-term threats. In terms of the short-term threats, what we've seen in the past few years is that the Supreme Court has struck down many pieces of legislation regarding 5 pieces of legislation regarding the asylum seeker community in Israel, mostly around imprisonment, indefinite imprisonment and deportation. And we are extremely worried that those laws will be re-legislated once an override clause is brought into question. Another law that was struck down by an ACRI appeal was the law of expropriation of private Palestinian land. That law is basically a way to legalize all of the illegal settlements in the West Bank. And that is very high on the agenda of the incoming government. Repassing of the law of expropriation of Palestinian land would make a two-state solution, which is already very, very difficult, much more difficult in the sense that it would create continuity of Israeli settlements over the West Bank, so ubiquitous that it would be very, very difficult to separate later. In addition to that, if we're looking at the threats, I'm moving down the list of threats that we're deeply concerned about. The last few years have been characterized by an extremely violent and inciting rhetoric around the political representation of Palestinian society in Israel in the Knesset, an attempt to delegitimize the Palestinian parties and their platform. And in the Israeli parliament, there's a process of disqualifications of parties before the election. So the process currently is that there's a parliamentary procedure of disqualifying parties. In every single election in the past 20 years, at least one Palestinian party has been disqualified. And then in every single election in the past 20 years, the Supreme Court reversed that decision. We are worried that with the override clause, the Knesset will eliminate the judicial oversight over the disqualification process, which would lead to denying political representation to large parts of Palestinian society in Israel, which would both revolutionize the map, deny political representation, and also, as we know, minorities that are not represented are usually radicalized. Are you still with me? Are you bearing this? We have a little more to go. In terms of other concerns, ACRI, as I think everyone around the world is worried about escalation in violence. Past cycles of violence have begun with changes to the status quo in the Al-Aqsa Mosque in Jerusalem. This government, members of this government have vowed that they want to change the status quo in the mosque. And so we are worried about another cycle of violence. These cycles of violence often lead to horrific casualties and deaths, but also to attempts to legislate and take away human rights. And again, the court has been the protector of human rights under these circumstances, and we're worried that the court will no longer be available to offer assistance. These are the very short-term threats. The longer-term threats is that the Supreme Court has been the protector of minorities, specifically LGBT minorities, women's rights, workers' rights have all been secured by the Supreme Court in Israel. And while currently the first steps that the government is planning are not targeting these communities. This could change either in this government in later years or in future governments. And so any protection of labor rights, such as the right to strike, is under attack. LGBT rights that have been guaranteed by the Supreme Court, anything from access to healthcare to family rights and women's rights. There have been calls in this government coalition negotiations to legislate permissions for gender segregation in the public sphere, and that if there's an override clause, that will also be something that we will have a hard time fighting legally. So all of these are the threats posed by the override clause. The good news that I have to share is that poll after poll is showing that the government that has not yet been formed has abysmal approval rating already, that the faith of the public and the support of the public in the courts has really increased dramatically since the elections. And we are working very hard with all of our partners, both to galvanize support from anyone from past judges to high school students to raise awareness and to fight this type of legislation. And we are already seeing that Prime Minister Netanyahu, the projective Prime Minister Netanyahu, is saying that the override clause will not happen in this Knesset session in the winter, but it will be postponed to the summer. So any postponement, because we know that Israeli governments usually don't last 4 years, any postponement is very good news for our struggle, and we will just have to be very fierce and keep it up until we manage to create a change in the government.
No, thank you. That's quite the list of threats. That's quite the, I mean, I think, the issue that we're dealing with here, I think, to point out some of the major similarities that I've heard people talk about is any notwithstanding clause in and of itself, an override clause is a threat to fundamental rights. It's not a good idea, it's bad. When we look at Israel's circumstance specifically, because of the reasons, the sort of weaknesses you pointed out in the lack of a more entrenched constitutional structure, it is even more a bad idea. It is even worse. And that the people in particular who are advancing it are the exact people who've been trying to get around the court's insistence on rule of law and equality on a great number of things. So it's not a great tool. It's even an even worse tool in, say, a democratic system like Israel. And then you definitely don't give it into the hands of the people who absolutely don't share the value of judicial review or the protections of minorities.
And it's very different in the sense that the way to enact the override clause is by a majority of 51% in the proposed legislation in Israel, and in Canada it's how many?
I mean, in Canada, it's entrenched already in our charter. I would say, without getting into it, that there are some people who believe that it is still necessary and could be valuable if used appropriately as a democratic protection. There are people who believe in rights who believe that, who don't believe in the supremacy of the courts for reasons that are historical, and seeing how courts have abused fundamental rights in the name of, constitutional protections. But I think that we are seeing the dangers very, very seriously, and the toothpaste is out of the tube now in Canada. We have a big fight on our hands.
Let's take, I've seen a few quick questions. We have about 10 minutes, maybe we'll squeak past the hour in my closing remarks, but otherwise let's see if we can spend 10 minutes just addressing some of the questions that came up. I have seen David Lepofsky, professor of law. David Lepofsky asks, Noah, has CCLA or Lorraine, has anybody tried arguing that Section 33 cannot immunize Quebec's law on hijab provision? because Section 28 doesn't allow Section 33 to be used to defend sexual discrimination. We also have a question from Marty Cutler to the two Noahs. How optimistic are you in overcoming the proposed Israel, Israel existing Canada override notwithstanding clauses? That's like, what can we do? What's our route for fighting back? And Barbara Landau asks, my concerns are also to the likely changes to the acceptance of Reform and conservative Jews, Jews of non-Orthodox background in Israel. What's expected on that? The impact of youth of Orthodox influence on education is quite large. There's a whole lot in there, and what can we do in the diaspora to impact it? There's a common thread around public protest. Is this an effective tool? That's quite enough, but I think I'll let you each take literally just 2 minutes each to hit what you want to hit of those questions, and then we'll wrap up. Thank you, everybody, for your questions. Whoever is ready to go first.
I can go first. So in terms of the rights of non-Orthodox Jews in Israel, thank you for reminding me. Of course, those rights have been also protected by the Supreme Court. Netanyahu has made statements in the past couple of days saying that he refuses to change the law of return in a way that would damage, would hurt the rights of Reform conservative conversions, but that's a very weak assurance. So absolutely, this is a critical issue. I think that we need to distinguish between hope and optimism. I've shared a very, very pessimistic map with you. I've also shared it in the chat in case you wanted to look. It's a 5-page document, all of it full of threats. But I think that the civil society in Israel is strong. And while democracies around the world are facing a populist wave that none of us quite know how to deal with, I think that the tide is changing, and that we as advocacy groups, as women, as Jews, as LGBT people have now more agency than we've ever had in the past to advocate for our rights. So while we are in terrifying times, this is a time where we are tested, and this is the reason why we advocate, and this is the strength of our tradition to fight for justice. So while I can say I'm optimistic, I can say that I'm determined, and that while we are concerned that this government will cause damage that will last generations, everything that we can mitigate or block or postpone will also have impact for generations. And public protest in Israel is important, and we will use it. And also advocacy around the world is important. We've already seen the impact of diplomacy on this government. So I thank you for everything that you do, or you're doing in NIF and in Arts of Canada and every other advocacy group. And I think that this is our time to work hard to make an impact.
Thank you, Noah. Thank you, Rabbi Noah. Noah Mendelsohn, Aviv, do you want to go after? Okay. Lorraine, are there any closing thoughts you want to offer us?
Sure, thank you. I want to say that the override is not, to my mind, the only huge problem here, because there are proposals to politicize the appointment of the judges in the Supreme Court, to have political appointment of the government legal advisors, restrictions on standing to bring court cases, 15 judges for the court to override, for the court to invalidate on the basis of rights protection, changes to the Office of the Attorney General, the removal of administrative law review in the courts in terms of executive rulemaking and executive adjudication by tribunals and officials on the basis of reasonableness, so that the whole rights-based constitutionalism, protection of human dignity apparatus in Israel is under threat of becoming totally politicized. And if you don't have an independent, secure judiciary, then because Israel doesn't have these other structures that Canada enjoys to a certain extent, as Rabbi Noah mentioned, then the override is a specific tool, but the whole institutional structure won't be there to necessitate the use of the override if there's a total politicization of the justice system.
In effect, the incoming government is looking to remove all of the stop signs and yield signs that protect minorities and vulnerable populations, even more so than already exists, which we know could already do a lot of, could already see a lot of improvement in Israel as it is. Noah, any closing thoughts about what we've learned from Canada in particular, or what we can do in Canada, for Canada, on our own issues?
Yeah, thanks, Ben. You know, as I said, the toothpaste is out of the tube. The governments of Quebec and Ontario have taken a provision in the charter that has always been there, and they've used it to violate fundamental rights. And the worst part is that most of the public doesn't really understand this yet. And CCLA has raised a hue and cry as much as we could with, you know, letter writing and media and op-eds and press conferences, and as much of a media circus as we are capable of in our small little nonprofit independent, but we really try to get the message out that every single right is at stake, that the solid rock that we thought we were standing on with the charter is a piece of paper. And the government is, and the government of Quebec and the government of Ontario and any other provincial or federal government can just tear off bits whenever they choose. That's how it stands right now, which is a very pessimistic view, but we did raise a hue and cry. There was a public outcry over Bill 28, and within 8 very, very, very long and busy days, it was defeated. The government withdrew that bill. So we're not done. There are going to be other governments that are looking and that are watching and are going to do the same thing if they feel like they have the public behind them. And that's what's happened in Quebec with Bill 21, where they have the public behind them and they're doubling down and they're getting great mileage out of this. And so, you know, CCLA is going to continue monitoring and continue telling, and we need everybody, because public outcry doesn't come from a little organization. It comes from, you know, all of you sharing with your friends, with your networks, getting involved, staying informed. We will be vigilant. We will raise the alarm. We're going to keep fighting, but we need everybody to fight alongside us. That is the most important thing that we can do, although we will continue to fight this in the courts and at the legislative level.
Thank you, Noah. Thank you, Noah Mendelsohn Aviv. Thank you, Rabbi Noah Sattath. Thank you, Lorraine Weinrib, for lending us your expertise, for joining us today. This has been incredibly substantive, very informative. There's lots to follow up on. We will send out some of the links that our speakers have referenced and have written themselves about this. Let me close with just a couple other things. Like, obviously, we're concerned for democracy around the world. We're concerned for our rights and fundamental freedoms in Canada, and we're really concerned for those in Israel. And though the challenges may seem really scary, even overwhelming, we're prepared. The importance of ACRI and CCLA is that civil society is important, crucial. It's also, in addition to the court, in addition to a free media, one of the pillars of a liberal democracy, that citizens can take action, that issues can be raised, that politicians can be pressured, as well as ideas proposed, alternatives advanced, and research done. This is what civil society contributes to a vibrant liberal democracy. And though Israel is a young country, it has, just by Noah's example, Rabbi Noah's example, an incredibly strong, a crucially strong civil society that can compensate for some of the other weaknesses that there may be there. The good news is that fully half of Israelis voted in the last election for the alternative to this government. And as they pointed out, the current incoming partners are seeing their popularity plummet. So if we look at our recent lesson in Ontario, of the Ford government having also a legislative majority to pass the legislation it wants, can get away with what it wants, nevertheless had to back down from using the notwithstanding clause due to public outcry. Politicians are often always looking about, can they get elected the day after? And civil society plays a role in making them pick their battles and choose where they're going to spend their efforts. And if something is just simply too costly, they will take another course. And I'll give you an example of that exact moment that happened in Israel on the issue of asylum seekers. In early 2018, the Israeli government, as Rabbi Noah referenced, was seeking to deport all African asylum seekers from Israel, summarily without even reviewing their asylum applications. And it advanced plans to do so. The public outcry was enormous, and it came from surprising quarters. Of course, it came from the Israeli human rights groups. Of course, it came from international diaspora Jewish voices. But it also came from El Al pilots who refused to fly, asylum seekers back to Uganda. It came from Holocaust survivors who said that this was too close to home for them. It came from low-income residents of the Jewish residents of the neighborhood that asylum seekers were sort of dumped into, South Tel Aviv. And to see a 10,000 person rally in South Tel Aviv where Mizrahi feminists who live in the neighborhood stood alongside African asylum seekers saying to Netanyahu, these people are not preying on us. We are not the victims here. You have not advanced solutions for us and for our neighborhood for decades. And we share common problems and common solutions with this vulnerable population. We are vulnerable together, and together we reject this assertion that they are violent rapists who are here to undermine our country. The government listened. Netanyahu at the time had the legislative, votes in order to advance his policy, but instead he went on TV the next morning and said, "I'm sorry, I cannot deport all the asylum seekers like I wanted to." And at the time, he incidentally said it's all the New Israel Fund's fault that I can't deport them tomorrow. He said so on primetime TV, and we wear that as a great badge of honor. But it just speaks to the power of protest. To the power of civic engagement, civil society, especially in a moment where we find ourselves with, say, certain governments at the provincial level in Canada, or in Israel, where there are no moderate partners in the governing coalition. So that is, I think, one of the key lessons that we're taking out of this moment, and one of the big things that you can do is to be involved. So once again, I thank you for joining us today. Thank you for our speakers for their expertise. This is being recorded, so you'll be able to get it and share it with others. Again, thank you all very, very much. Have a lovely afternoon.